excuse me, guilty to the charges of possession of less than 25 grams of heroin, possession of analogs, both in the second. Bring up the jurors. Counsel, what I've been handed is a set of jury instructions that are agreed upon by both counsel. Is that right?
Yes, Your Honor. Mr. Cataldo furnished me a copy earlier today. I've gone through them. I'm satisfied.
All right, and these are in the order and form you both want them given?
They are.
Yes, Your Honor.
Okay, very good.
All rise to the jury, please.
May you be seated? Jury, the evidence arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence. You must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. lawyer's statements and arguments and any commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, summary of the evidence, and instructions are also not evidence. Actually, I'm going to strike summary of the evidence because I didn't give you any summaries of the evidence, so disregard that. Let me start over. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influence that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raindrop covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. If you believe that a witness previously made a statement inconsistent with his or her testimony at this trial, the only purpose for which the earlier statement can be considered by you is in deciding whether the witness testified truthfully in court. The earlier statement is not evidence that what the witness said earlier is true. Evidence has been offered that one or more witnesses in this case previously made statements inconsistent with their testimony at this trial. You may consider such earlier statements in deciding whether the testimony at this trial was truthful and in determining the facts of the case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason, by itself, is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that she meant to do so. The testimony of Randy Simon was read into this trial because he was not available. This testimony was taken under oath at an earlier hearing. You should consider this testimony in the same way you consider any other testimony you have heard in court. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer or a lawyer's representative talked to one of the witnesses. There is nothing wrong with this. A lawyer or a lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have heard evidence about the defendant's character for peacefulness, honesty, and being law-abiding. You may consider this evidence, together with all the other evidence in the case, in deciding whether the defendant committed the crime with which he is charged. Evidence of good character alone may sometimes create a reasonable doubt in your mind and lead you to find the defendant not guilty. The prosecutor has cross-examined all of the defendant's character witnesses as to whether they had heard anything bad about the defendant. You should consider such cross-examination only in deciding whether you believe the character witnesses and whether they describe the defendant correctly. You have heard testimony from the following witnesses. Stan Brew, who has given you his opinion as an expert in the fields of forensic analysis of cellular cell detail records and power mapping. Dr. Daniel Spitz has given you his opinion as an expert in the field of forensic pathology. Amy Atzleben has given you her opinion as an expert in the field of DNA. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons should also think about the expert's qualification and whether his or her opinion makes sense when you think about the other evidence in the case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of other witnesses. The defendant is charged with 3 counts, that is, with crimes of first-degree murder, which includes the lesser included charge of second-degree murder, disinterment and mutilation of a dead body, and removing a dead body without permission from the medical examiner. These are separate crimes. The prosecutor is charging that the defendant committed first-degree murder, disinterment and mutilation of a dead body, and removing a dead body without permission from the medical examiner. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all of the crimes, any one of these crimes, or not guilty. The defendant is charged with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Ramsey Scrivo. That is, that Ramsey Scrivo died as a result of strangulation. Second, that the defendant intended to kill Ramsey Scrivo. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose her actions before she did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. Fifth, that the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. The defendant is charged with the crime of first-degree murder. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Ramsey Scrivo. That is, that Ramsey Scrivo died as a result of strangulation. Second, that the defendant had one of these 3 states of mind. She intended to kill, or she intended to do great bodily harm to Ramsey Scrivo, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. The defendant is charged with disinterment and mutilation of a dead body. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant mutilated, defaced, removed, or carried away a portion of Ramsey Scrivo's dead body. Second, the defendant was not lawfully authorized to do so. And third, the mutilation, defacement, removal, or carrying away was not necessary to embalm the body or to conduct a post-mortem examination. The defendant is charged with removing a dead body without permission. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant removed Ramsey Scrivo's body from the place where his death occurred. Second, when she did so, the defendant knew or should have known that Ramsey Scrivo died suddenly, unexpectedly, accidentally, violently, or as a result of suspicious circumstances. And third, the defendant removed Ramsey Scrivo's body without first notifying or receiving permission to remove the body from the county medical examiner or deputy county medical examiner. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about January 25th, 2014 through January 31st, 2014 within Macomb County. The alleged crime in this case is made up of several acts. The prosecutor only has to prove that one of these acts took place in Macomb County. He does not have to prove that all of them took possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. When you go to the jury room, you will be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual, considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. In this case, there are several different crimes that you may consider. For the crime of first-degree murder, you may consider the lesser included offense of second-degree murder. When you discuss the case, you must consider the crime of first-degree murder first. If you all agree that the defendant is guilty of that crime, you may stop your discussions and return your verdict. If you believe that the defendant is not guilty of first-degree murder, or if you cannot agree about that crime, you should consider the less serious crime of second-degree murder. You decide how long to spend on first-degree murder before discussing second-degree murder. You can go back to first-degree murder after discussing second-degree murder if you want to. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are following. I have prepared a verdict form listing possible verdicts. Madam Clerk, at this point, excuse one juror, please.
Juror number 6.
You can step in here, sir, and grab one yourself. I'll be right with you.
All right, please swear Deputy Ryan at this juncture.
Do you solemnly swear that you will keep this person sworn as jurors in a private place, that you will not communicate with them orally or otherwise unless ordered by the court, and that you will not communicate to anyone the state of the deliberations until they have rendered the verdict? So help you God.
Yes, I will.
All right, ladies and gentlemen, at this point in time, please begin your deliberations.
All rise to the jury, please.
may be seated.